Right now, at this very moment, ICE agents are walking through the terminals of America's busiest airports. Travelers are confused, immigrants are afraid, and a federal court just handed down a ruling that could protect millions of people from being locked up without bail. This is not speculation. This is happening today, March 24th, 2026. And if you or someone you know travels through a U.S. airport, has an immigration case, or is waiting on a visa, you need to watch this video until the very end. Welcome to Global Immigration Scope. Let's break this down. Today, we are covering three major immigration developments that are directly affecting immigrants, travelers, and visa holders inside the United States right now. Number one, ICE agents have been deployed to more than a dozen major U.S. airports starting March 23, 2026. Number two, a federal court lawsuit and ruling is protecting many immigrants from being denied bond and held in detention indefinitely. Number three, we will explain what the visa bond situation means and what rights immigrants currently have. All of this information is based on verified reports from official sources, including the Department of Homeland Security, U.S. Immigration and Customs Enforcement, federal court filings, and credible news organizations including CNN, Al Jazeera, PBS NewsHour, and the National Immigration Law Center. Let's start from the beginning. Starting Monday, March 23, 2026, the Trump administration deployed hundreds of Immigration and Customs Enforcement, or ICE agents, to at least 14 major U.S. airports across the country. The airports confirmed to have ICE presence include JFK International Airport, New York, Hartsfield-Jackson, Atlanta, International Airport, Atlanta, George Bush Intercontinental Airport, Houston, William P. Hobby, Airport Houston, O'Hare International Airport, Chicago-Philadelphia International Airport, Newark, Liberty International Airport, New Jersey, Louis Armstrong New Orleans International Airport, Pittsburgh. International Airport and White House border Czar Tom Homan confirmed that the number of airports could increase further. Now, why did this happen? This deployment was triggered by a serious staffing crisis at the Transportation Security Administration, better known as the TSA. Here is the background. Since mid-February 2026, a partial government shutdown has left the Department of Homeland Security, which oversees the TSA without approved funding. That means approximately 50,000 TSA officers have been working without pay for over 6 weeks. The financial pressure has caused a serious problem. According to DHS figures, nearly 400 TSA officers have quit since the shutdown began. And on Sunday, March 22, 2026, nearly 12% of TSA officers, that is more than 3,450 workers, did not show up for work. That was the highest single-day absence rate since the shutdown started. At some airports, the situation became alarming. At Hobby Airport in Houston, 55% of officers were absent on March 14th. At Atlanta's airport, call-out rates topped 40% on some days. At JFK in New York, travelers reported waiting nearly 2 hours before 7 a.m. to get through security. In Houston, airport officials warned travelers it could take more than 4 hours to get through security. With spring break travel in full swing and millions of passengers moving through airports, the Trump administration chose to send ICE agents in to help manage the situation. What exactly are ICE agents doing at airports? This is a very important question, and there is a lot of confusion about it. According to official statements from DHS and Tom Homan, ICE agents are not replacing TSA officers and are not conducting passenger security screenings. ICE agents cannot operate X-ray machines, run metal detectors, or conduct baggage inspections. That requires specialized TSA training. Former acting ICE Director John Sandweg confirmed this on PBS, explaining that ICE agents simply do not have the same security clearances or technical training for those tasks. What ICE agents can do, and what they have been assigned to do, includes managing long lines and controlling crowds, guarding exit doors at terminals so TSA agents can move to screening checkpoints, providing a visible law enforcement presence inside terminals. Atlanta Mayor Andre Dickens confirmed that the federal officers deployed to his city's airport were assigned to line management and crowd control within domestic terminals, and that the deployment was not intended to conduct immigration enforcement activities. But, and this is a critical but, President Trump himself told reporters aboard Air Force One, They love it because they're able to now arrest illegals as they come into the country. It's very fertile territory, but that's not why they're there. So while the official purpose is crowd management, the president's own words have raised serious concerns among immigrant communities, Democratic lawmakers, and immigration advocates about whether ICE agents will use their airport presence to conduct immigration arrests. Democratic senators condemned the deployment and shared travel safety tips for immigrants passing through airports. Why is the shutdown happening? The shutdown comes down to a political standoff in Congress. Democrats refused to support the DHS funding bill unless changes were made to immigration enforcement policies. Their demands included requiring ICE agents to clearly identify themselves and banning racial profiling. These demands came after a deadly immigration enforcement incident in Minneapolis where 2 U.S. citizens were shot and killed by federal agents. Republicans rejected those demands. The result? A deadlock, no DHS funding, no TSA paychecks, and now ICE in your airports. As of today, March 24, 2026, there is no deal in sight, though Republican lawmakers indicated they may be unifying behind a plan to reopen DHS funding. Now let us talk about the second major development, one that directly affects millions of immigrants who are currently in the United States, particularly those who entered without legal permission. Here is what ICE tried to do. In 2025, ICE issued an internal memo changing its legal position on immigration detention. The memo stated that immigrants who had entered the U.S. without authorization, even if they had lived here for many years, even for decades, should be classified as applicants for admission under Section 235 of the Immigration and Nationality Act. This legal classification is crucial because it means those individuals would be subject to mandatory detention with no right to a bond hearing before an immigration judge. In plain English, ICE was saying that these people could be locked up indefinitely while their immigration cases moved through the courts, with no opportunity to pay bond and return home to their families. According to reporting by The Washington Post, this policy could apply to millions of immigrants who crossed the U.S.-Mexico border over the past several decades and now reside in the U.S. immigration courts across the country, including in New York, began denying bond hearings to immigrants based on this new ICE position. The lawsuit. In response, the Northwest Immigrant Rights Project, NWRP, filed a lawsuit against ICE challenging this policy. The case is known as Maldonado Bautista versus DHS. The lawsuit argued that it was illegal to deny immigrants bond hearings simply because of how they had originally entered the country. On November 25, 2025, a federal court issued a ruling in favor of immigrants, overruling an Immigration Appeals Board decision that had supported ICE's position. The court found that many immigrants inside the U.S. still have the legal right to a bond hearing. Then, on February 18, 2026, the same court issued a second, stronger order, because lawyers brought evidence that the government was ignoring the first ruling. The February order directed the government to stop denying immigrants the right to ask for bond, inform detained immigrants of their rights in writing. In both English and Spanish, post this information on the online detainee locator system. Where does this ruling apply? As of now, the ruling directly protects individuals detained within the Central District of California. However, there is an important development. The plaintiffs have also requested class certification, a legal step that, if granted, could extend this protection to immigrants across the entire country. It is important to note that the U.S. Court of Appeals for the Ninth Circuit has temporarily stayed parts of this ruling outside of California while it considers the government's appeal. So, the legal battle is still ongoing. Let me now break down the most important details you need to know. Regarding ICE at airports, ICE agents were deployed to at least 14 airports starting March 23, 2026. Their official role is crowd management and guarding exits, not security screening. ICE agents cannot operate TSA equipment. They lack the training and clearances President Trump confirmed they can and may make immigration arrests. This is directly connected to the DHS funding shutdown, not a standalone immigration enforcement operation. The White House's border czar said the number of airports could expand. Regarding the bond lawsuit, ICE policy tried to classify all undocumented immigrants as applicants for admission, making them ineligible for Bond. A federal court overruled this position in November 2025 and again in February 2026. The ruling currently protects immigrants in the Central District of California. The government is appealing the ruling in the Ninth Circuit Court. A class certification request could expand the protection nationally. Immigrants who believe they qualify should speak to an immigration attorney immediately who is at risk at airports. According to the National Immigration Law Center, the following individuals face the highest risk at U.S. airports. People with old deportation orders, even if they did not know about them. People whose temporary status has been revoked, including TPS, CHNV parole, CBP-1 program holders. People with pending immigration applications. Undocumented individuals traveling domestically. What does all of this mean for you? For immigrants? For travelers? For families? For travelers generally, the IC deployment means you may see uniformed immigration officers in airport terminals. If you are a U.S. citizen or have valid immigration documents and your status is stable, the official guidance is that this deployment should not directly affect you. However, legal advocates strongly recommend that immigrants carry their immigration documents at all times. For undocumented individuals or those with uncertain status, the risk level at airports has increased significantly. Even if ICE's official mission is crowd management, the presence of ICE agents, combined with President Trump's own statements, means that arrests can and may happen. For the millions of immigrants affected by the Bond ruling, this is a significant legal victory, but it is not complete. The ruling gives many people the right to ask for bond. It does not guarantee release. Immigration judges still evaluate individual cases, and ICE may still argue for detention. But having access to a bond hearing is a fundamentally different situation than being held with no hearing at all. For the wider immigration system, the DHS funding crisis is causing real harm. TSA workers are suffering, travelers are facing enormous delays, and the use of ICE agents, whose core mission is immigration enforcement, in a TSA support role is blurring important institutional lines in ways that may have long-term consequences. On the airport ICE deployment, the immediate trigger is the DHS shutdown. If Congress reaches a funding deal, and as of today, Republican lawmakers appear to be moving toward one, TSA officers will eventually return to full staffing, and the need for ICE at airports would decrease. However, the immigration enforcement precedent that has been set, ICE presence in major civilian travel hubs, is unlikely to disappear entirely if it proves effective for the administration's broader enforcement goals. On the bond lawsuit, this legal battle is far from over. The Ninth Circuit Court of Appeals will make a ruling on whether to extend or lift the stay. If the court sides with immigrants, the protections could expand nationwide. If the government wins the appeal, millions of immigrants could again face mandatory detention without bond hearings. This case may ultimately travel all the way to the U.S. Supreme Court, making it one of the most consequential immigration cases in years. On the broader immigration climate, 2026 is shaping up to be one of the most legally and politically charged years in modern U.S. immigration history. Between executive orders, court battles, funding shutdowns, and enforcement escalations, the landscape is changing rapidly. Immigrants and their families should stay informed, consult qualified immigration attorneys, and document their status carefully. First, ICE agents have been deployed to at least 14 major U.S. airports as of March 23, 2026, due to a TSA staffing crisis caused by a partial DHS funding shutdown. Their official role is crowd management, but immigration arrests remain possible. Second, a federal court ruled in the Maldonado Bautista case that many immigrants have the right to a bond hearing before an immigration judge, protecting them from indefinite detention without bail. The ruling currently applies in California, and the legal fight over nationwide protection is ongoing. Third, if you or a family member may be affected by any of these developments, please consult a qualified immigration attorney as soon as possible. Know your rights, carry your documents, stay informed. Thank you for watching Global Immigration Scope. Stay informed and subscribe for the latest immigration news and visa updates from around the world.